All right, so we're going to look at civil liberties. Okay, civil liberties are basically the protections that the Constitution provides individuals against the abuse of government power. So it's basically constitutional protections for individuals against government actions. Okay, state ratifying constitutions did demand the addition of the Bill of Rights, and it's going to take a process of time for the Bill of Rights to become something that states must also uphold. So that's what we're going to kind of look at here. So let's start with the 14th Amendment, 1868. Two really important clauses here. We have the Due Process Clause. No state shall deprive any person of life, liberty, or property without due process of law. So this clause is the basis of civil liberty cases. Then there's the Equal Protection Clause, which states no state shall deny to any person within its jurisdiction the equal protection of the laws. Now, this clause is the basis for civil rights cases, so definitely know the difference between the two. All right, so let's begin to look at kind of the idea of selective incorporation. One of the first cases is going to be 1955, Gitlow. This is going to declare federal guarantees of freedom of speech and freedom of press must also be applied by the states. So it's basically saying that the Bill of Rights apply to actions by the states. The states don't and can't suppress your speech and press. This is known as selective incorporation. All right, so the First Amendment, right, protecting freedom of speech, press, assembly, religion, and petition. All right, freedom of religion is protected in two clauses here. It's the Free Exercise Clause, and it's the Establishment Clause. Freedom of expression is a general rule that the court does not permit or restrain material prior to publication. Okay, this is seen in the Pentagon Papers case. We'll look at this in class. There are limitations on freedom of expression, right? And this really is about clear and present danger and defamation and obscenity. So these are the limitations on it. So defamation is the idea of libel, which is a written false statement defaming another person or entity. And then there is slander, a defamatory oral statement, right? Okay, so one is just verbal and one is written. All right, so public figures kind of show the words were written with actual malice, reckless disregard for the truth, or with knowledge that the words were false. So this is usually what people, especially famous people, sue tabloids on, okay, because it's malice and it's reckless, completely void of any truth. All right, so obscenity. Okay, this is kind of big. The court is going to sort of define obscenity. So in Miller v. California, all right, judged that the, quote, average person applying contemporary community standards, okay, to appeal to the purest interest or to depict in a patently offensive way sexual conduct specifically defined by applicable state law. So basically, the court is saying any average person, if they see something and they deem it to be inappropriate or obscene, then that is the definition of obscenity. The court is going to go back and forth on this, and we'll talk about it in class. Okay, then there's symbolic speech. So generally speaking, the First Amendment protects the symbolic speech, right? Like flag burning. You might not agree with it, but it is protected speech. In a case Tinker v. Des Moines, the court's going to rule that the students do not leave their rights at the schoolhouse gate as long as the speech does not disrupt the educational process. So protest is okay. Walk in with a shirt protesting something, totally fine. You just can't disrupt the classroom or the educational process. Okay, prior restraint. All right, this is the idea is that censorship is imposed by the government on your expression. So in New York Times v. U.S., the court is going to rule that there is a heavy presumption against prior restraint, so against censorship imposed by the government. So you can't just censor something before it comes out. Commercial speech. Commercial speech is advertising, TV, radio. FTC prohibits false claims, right? So infomercials, when they say that you can spray their sealant on the bottom of a screen and go float in the water, you better be able to do it. You can't make false claims. In the FCC v. Pacifica, the court is going to uphold restrictions on foul language over public airways. So you cannot curse on TV, radio, etc. Now, there's a loophole on this, right? So like Sirius radio, things like that. It doesn't totally apply because that's not public, that's private. You are paying for your subscription. All right, then there's the free exercise clause, okay? This is going to ensure that no law can impose particular burdens on a religious institution, okay? It prohibits, all right, the abridgment of freedom to worship or not worship, so you can't be forced to worship a certain way, you can't be forced to not worship. Some conflicts between religious freedom and public policy are kind of difficult to settle, but basically you can practice your religion and the traditions that go with your religion. So you can meditate, you can pray, you can go to church, you can do these things. The only thing it does not protect, obviously, is sacrifices. Okay, the establishment clause. Basically, government involvement in religious activities is constitutional if it meets a certain test, okay? So there must be a secular purpose, okay? The primary effect neither advances nor inhibits religion, okay? And no excessive government entanglement with religion. The idea is that there's a separation between the church and the state, that there is no praying in schools per different Supreme Court cases, that there just needs to be this different separation, okay? And that the government cannot say we are a Christian government, we are a, therefore everybody needs to practice that, okay? All right, so let's look at the Second Amendment. So McDonald v. Chicago is the most recent case, all right? And the court is going to rule that the Second Amendment's right to bear arms cannot be taken away by the states. States may enact reasonable regulations on the possession of firearms, but they cannot take them away. Okay, so you can have certain background checks, you can have certain policies and procedures, you can even restrict the sale of certain types of guns, but you cannot take away the right. Fundamental. Rights of defendants. Okay, so this is the Fourth, Fifth, Sixth, and Eighth Amendments, right? Fourth protects against unreasonable searches and seizures. You need a warrant, right? The Fifth Amendment protects against self-incrimination, so you don't have to testify against yourself. The Sixth Amendment says the accused has a right to counsel, and the Eighth Amendment prohibits excessive bail and cruel and unusual punishment. So let's look at these. So there's something called the exclusionary rule. So in Mapp v. Ohio, the court established this rule. Basically, evidence gathered in violation of the Constitution cannot be used in trials. So if you have a search warrant for one thing, you can't go searching everywhere else, okay? If your warrant is only for the garage, you can't go search in the house. So the exclusionary rule stems from the Fourth Amendment, freedom from unreasonable searches and seizures, as well as the Fifth Amendment. So a search and seizure. A properly obtained warrant is an order from a judge authorizing the place and describing what it is you're searching for. Okay, you can't just have a blanket open door. A judge can issue only if there's probable cause. Okay, so there must be some evidence there. Okay, and so what can the police search? The individual being arrested, obviously, they need to be safe, so they're going to search you before arresting you. Things in plain view, if you've got something right there inside your front door, in your car, something like that. Things or places under the immediate control of the individual, like the car. So confessions and self-incrimination. So this is the infamous Miranda v. Arizona, okay, where the court rules that confessions are presumed to be involuntary and cannot be used in court unless the suspect is fully informed of their rights, which is why we have the Miranda rights. Okay, the right to counsel. Even though the Sixth Amendment, right, provides the accused with the right to have assistance, okay, Gideon v. Wainwright of 1963 says the state must provide an attorney in a felony case if the accused cannot afford one. All right, so the Sixth Amendment says they have a right to one, but what if that person can't afford it? Okay, the Gideon case says even if they can't afford it, they must be given access to an attorney. All right, and then the death penalty. Oh my. So Furman v. Georgia, 1972, the death penalty, all right, was applied, all right, and seemed random, all right, and in this case was seen as unconstitutional. States are going to rewrite their death penalty statutes, okay? And then in Gregg v. Georgia, the death penalty is going to be seen as an expression of society's outrage and is okay. So the Supreme Court's going to go back and forth on, is it cruel and unusual? Is it not? What can we do? And we'll look deeper into these cases and the discussion and debate in class. All right, get this into your notes, update everything. If you have questions, write them down and bring them in. Until next time.